global structures, which have really been in place for the last 35 years, since the end of the Cold War, really. I will say something more about the crisis in the Middle East, and also the wider effects on shipping of the conflict in Ukraine, in particular, the unintended consequences of the G7 sanctions. Then my second theme, which is really linked to the first, is the importance of maintaining global rules for the global industry and how we must protect the very successful global framework we enjoy for shipping and the danger we risk if we take this for granted. Then finally, if I get there, against this rather depressing background, I'll consider if there is anything that we can do better as an industry to better promote potential solutions. That one. So just to explain, I'm speaking on behalf of the International Chamber of Shipping, ICS, and we're the global trade association for ship owners. We represent all sectors of trade, so that includes tankers, bulk carriers, container ships, and general cargo ships, and car carriers, of course. We were established over 100 years ago, and our authority, really, to speak for the industry is derived from our membership of national ship owner associations. We cover it's about 42 countries in Asia, the Americas and Africa, and also in Europe. We hope in due course that the Bulgarian Ship Owners Association will also rejoin ICS, so that it too can help to influence the development of our policies and the positions which we then represent to our global regulators. And the core of our work really is representing the global industry with all of those intergovernmental bodies that impact on shipping, in particular, of course, the IMO, which is based in London, like ICS. But we also represent the industry with other bodies and institutions. That includes the United Nations in New York, but also the World Trade Organization, the WTO in Geneva. Shipping, of course, is the servant of world trade, and the demand for shipping services and the efficiency of maritime transport is deeply affected by protectionist measures. And when we emerged from the COVID pandemic, we commissioned a detailed study from Harvard University, and big title, Protectionism in Maritime Economies. But the main conclusion was that if countries can reduce their restrictive maritime free trade policies, this could actually help boost their GDP by up to 3.4%. It's quite a significant finding. But it's no coincidence, really, that the massive growth in shipping and shipping services, which we've seen, really since the end of the Soviet Union, was that 1991, has really been due to the establishment of the World Trade Organization. But unfortunately, the WTO system of arbitrating trade disputes between governments has, in effect, broken down. And shipping is especially vulnerable because free trade principles for shipping were never actually codified in that's what's called the General Agreement on Trade in Services, which was established in 1995 when WTO was established. Now, over the past 30 years, there have been endless negotiations, and many governments have made very detailed, non-binding commitments on issues such as market access for foreign ships, and the end of cargo reservations, cargo preference for national flag shipping. But for several years now at the WTO, these negotiations on maritime free trade principles, in effect, they've been suspended. The negotiations have broken down. So this means we are really vulnerable compared to other industrial sectors to these new protectionist pressures we see in the world. In particular, the new protectionist sentiment we've seen in major economies like the United States since President Trump was elected in 2016. But this movement towards protectionism is now being emulated by the Biden administration with measures such as the US Inflation Reduction Act. And it's also being copied by the European Union, which, as you know, is introducing protectionist measures against China, including specifically going to affect shipping against the new tariffs against Chinese electric vehicles. And then on top of this, we've got further evidence of a real new atmosphere of protectionism. Quite recently, the United States Trade Representative launched an investigation into the alleged unfair trade practices of Chinese shipbuilders. And the remedy which has been proposed is for penalty fees to be imposed on any ships, that's any ships that were built in China which trade to the US. And given that about half of the shipping fleet is built in China, this is clearly a serious concern. Moving on, the security situation, it still remains really severe. The attacks by the Houthi militia continue, and there's now an increasing possibility of a major regional war between Israel and Iran, or its Hezbollah proxies in Lebanon, in addition to the ongoing conflict in Gaza. So, as we all know, I think this crisis is having a profound effect on trade flows and transits through the Suez Canal. They're 60% lower than normal. As a minimum, we expect this crisis to endure for as long as Israel's campaign in Gaza continues, though it's possible that even if there was a ceasefire, the Houthis would continue to either to refuse to accept the ceasefire or else they'll just simply continue to target shipping because of the attention they gain internationally from this. More recently, with the recent Hezbollah attacks against Tel Aviv, there is concern that if the conflict expands, the attacks against ships could extend to the eastern Mediterranean. Moving quickly, for the time being, the United States and the EU military navies, they are committed to providing defence to shipping in the region. But whether this is going to be feasible in the longer term will depend on really political and geopolitical factors that are largely beyond the industry's control. And already we've seen the schedules that have been published by the liner companies for next year, and they plan to continue using the Cape route. Just moving on to Ukraine. There's no end, sadly, in sight to this really terrible conflict. But apart from the obvious, really serious threat to the lives of seafarers, the war is having other serious and unintended consequences on the shipping industry. And the problem, of course, is that the trade sanctions which the West has decided to impose on Russia are not United Nations sanctions. And that includes sanctions on the carriage of ships carrying Russian oil. So that means they don't apply to nations like India and China, which are happy to continue importing cut-price Russian energy. Now, because of the long reach of US sanctions, with almost all reinsurance ultimately being routed via the United States, ships carrying Russian oil cargoes can't obtain marine insurance through the normal channels. And I think our colleagues will talk more about that in a moment. And that also includes the international group of P&I clubs. So this has led to a big word, but a bifurcation, a divide of the global shipping fleet, and the emergence of what many call the so-called shadow fleet, which, although trading legally under international law, is outside the normal oversight of national authorities, such as port state control in Europe. And this creates uncertainty about the robustness of the insurance that's being provided in the event of serious pollution incidents. And this really leads me to my second theme. Shipping, we know, is a global industry which, to serve the world economy and to operate efficiently, enjoys this really incredible comprehensive framework of global regulation. So if a ship sails from, I don't know, from VARNA to Valparaiso, the same rules are obviously required at both ends of the voyage. Otherwise, we have chaos and economic inefficiency. So that's why it's so important for governments to respect this unique maritime legal framework, and also for governments to maintain the special level of cooperation with other governments, which they usually demonstrate on shipping matters, regardless of any major geopolitical differences they have on other issues. Now, the vital importance of the global regulatory framework, it's all about ensuring safe and efficient operations of shipping. Some governments understand this very well, especially if they have significant maritime sectors, and also if there's a strong maritime sector in a small country. Case in point, perhaps, is Denmark or Greece or Hong Kong or Singapore. But in the major economies, the United States, and unfortunately in most of Europe, the critical importance of shipping, it's simply out of sight of senior politicians and policymakers. And that's also the same when it comes to understanding the importance of our global regulatory framework. And we really are facing a danger now that this framework, which has existed for over 100 years, is under serious threat from unilateral action by individual nation states, which are at variance to the rules agreed by IMO. So regardless of differences governments may have today on other questions, it's really of the utmost importance that governments continue to cooperate and communicate on shipping policy questions. And one of the great strengths, actually, of the IMO process is that, regardless of political differences on big questions, up until now, regulatory questions affecting shipping have, for the most part, been taken on the basis of their technical merits. But we are becoming concerned that we're really seeing an increasing politicization of discussions at IMO, and an erosion of that famous spirit of IMO cooperation. We see this in particular with regard to the greenhouse gas negotiations, and they start again next week in London. And we've really seen this tendency. It really started 20 years ago when the member states of the European Union increasingly started to operate as a bloc, coordinated from Brussels. And there's a danger that many non-EU states may no longer feel the same sense of ownership of what is agreed at IMO. Was that my final? Yeah, thank you. So anyway, we're increasingly seeing at IMO the emergence of blocs, So as well as the EU, China and Brazil are forming blocs with developing countries. And we're just really at risk of losing the special processes that we had for developing consensus on shipping issues at IMO. Right, just to wrap this up then, I was going to say a few general remarks about threats to UNCLOS, but I'll skip that other than to say there are serious concerns that governments. An example I'll give you very quickly is the UK government has recently introduced a law to impose the UK minimum wage on foreign flag ships visiting the UK. The issue is not about wages. Our concern is not about the wage issue or what wages seafarers should be. That's a separate topic. Our concern is that this shows a complete disrespect for the UN Convention of the Law of the Sea that establishes that social conditions on board ship are the responsibility of the flag state. So if you have governments like the UK not showing respect for UNCLOS, then that sets a very bad example to others who may copy the UK and then introduce measures in conflict with other areas of UNCLOS, potentially even on issues such as freedom of navigation. Anyway, our maritime lawyer asked me to highlight that point. Right, what can we do then to finish? Despite all these differences and all these geopolitical challenges we face, it's really important that we encourage governments to continue talking to each other on shipping issues. So we're actually planning in cooperation. It's a really big event with the government of Hong Kong, which of course is now a part of China, but has a separate system and is committed to maritime free trade principles. We're organising a global summit, and this will be taking place on the 17th and 18th of November. And we're inviting senior policymakers from both Western and non-OECD countries. And the theme of this big event is risk and resilience in an age of disruption. So it's our intention really to try and start a dialogue that we hope can start to persuade governments that they have to reaffirm their support for free trade principles and the importance of global rules for our global industry. I'm sorry that was a bit rushed, but we got there in the end, and I hope that was interesting, and look forward to your discussion, our discussion in a moment. Thank you.
Simon Bennett, I can't believe we have Simon Bennett today. We've tried to attract Simon Bennett 3 years ago for a similar event, and we didn't succeed back then. But today we have Simon Bennett, the Deputy Secretary General of ICS, which was really impressive and invigorating. I did personally get very intrigued by the concept of freedom of navigation and also social conditions of crew members on board ships entering the UK jurisdiction. So that's a really interesting topic to elaborate on, perhaps in the Q&A or on another occasion. Now, moving on with the panel, we've decided to do a bit of reshuffling because we had a recording of Nick Shaw, but we'll leave that for the end. So let me have a quick check what follows. We have the Italian guy, Guillermo. Please give it up for Guillermo Camera one more time. I sort of virtually met Guillermo at another conference where both of us were lecturers. I spoke on sanctions, he spoke on war cover, and I'm starting to believe this is his probably hot topic because he's prepared something for us that's also dedicated on war conditions. Is that right, Guillermo?
Yeah, it is.
Okay, Guillermo has been very kind to fly from Italy to Bulgaria today, so let's please welcome him and follow up his presentation.
Thank you very much. So, I am one of the two lawyers. You can spot the lawyers in the room because you're the only one wearing ties, I think, apart from Simon. Okay, thank you very much to the organizer. Thank you very much to Yavor for inviting me to this wonderful event. The hospitality is great, VARNA is great, and today I was asked by the organizer to introduce you to the magic word of the war color. Is anybody in the room any familiar with the work order? Could you raise your hand who is familiar with work order? Well, come on, yeah. Okay, Ron, you're not allowed to make any questions. I'm a lawyer. I'm boring just because I'm a lawyer, but I will try to be as easy and soft and quick as possible. Okay, let's move on. First thing. So I was saying, first thing which we'll go through is the Institute War and Strike clauses. These are set of clauses which are very familiar in the Italian market, and I'm sure are also very familiar in the English market, when Ian can confirm afterwards. I will not go into the details because otherwise I will fall asleep. The only thing that I want to highlight you, what is covered about this kind of insurance policy. We're just focusing on the vessel, so we are not concerned about the crew, okay? Just the hull and machinery of the vessel. Traditionally, what the world cover, where the world cover operates, are the risk that you can see after me. So one is the typical war-like scenario, war-like operation. So typical example, a vessel which is torpedoed, or a vessel which goes on a mine, or which is which is harmed by any firearm. This is a typical class of things which falls into the first one. The second one is any kind of situation where the vessel is basically prevented from leaving the position where she is. There are many, as you can see from the wording, there are many different terms used: capture, seizure, detainment, arrest. I will not go into that. The only thing that you have to think about, but the vessel is stuck there, it cannot move. So there is an order by the court or by the local government, but the vessel is prevented to leave from there. There must be a physical dispossession of the vessel. Sorry, there must be a dispossession of the vessel by the owners, which does not mean physical dispossession. There can also be the crew on board, but the owner is prevented from ordering the vessel to move that position. When a vessel remains stuck for a certain amount of time, usually it's 12 months, then the owners can claim for a total loss, okay? The third one is the one that you might find nowadays in the Persian Gulf, is Terrorism Act for political motives. So, or any person acting maliciously. What does it mean? I mean the person with a willful intent to create any damage to the vessel. This is the English system. With the English system, there is also another set of clauses, which is the Nordic plan, which is a set of clauses which comes, as the name says, from the Nordic market. As you might know, the Nordic nowadays has become the leaders in hull and machinery and war insurers. They pass through the English, and they got the largest premium in the world are now placed in the Nordic market. I'm sorry about that, Ian. And basically, the Nordic plan cover more or less the same thing of the war and strikes. We will not get into that details. I don't want to be technical about that. In broad terms, the kind of cover which the Nordic people provide are the same. The only difference which the Nordic has are two peculiarities, because the Nordic learn from the experience of the English and try to get it better. The Nordic plan is, first of all, a set of clauses which is renewed from time to time. So it's not a static clause which has been created and that's it. There is a standing committee who renew the clauses from time to time. The last version is 2013 with renewal in 2023. So they can adapt the clauses to the situation in which they present the coda. The second thing, which is not good for the lawyers, is that the Nordic plan comes out with a commentary. So the drafter of the policy issued a commentary, so in order to understand how these clauses are constantly interpreted, so this should prevent any litigation. This is what is covered. If we look at the exclusions, you will understand more or less what is the kind of cover which these clauses provide. I didn't go into any kind of exclusions, and I didn't make a distinction between a Nordic plan and a war and strike. I tried to group them together in order to give you a glance of what they do not cover. The first thing is whenever an order of the law of the flag is issued. So if there is an order by the law of the flag of the vessel by which the vessel is prevented to leave from that place or is caused any harm or danger or loss to the vessel. This is not covered. The reason is more, I think, traditional, because the presumption is there is an order by the law of the flag. This might be legal or administrative infringement by the owner, so that not provide any cover at all. The second one, sorry, I'm not following this order. The second one is whenever the owner is facing any financial issue. So if the owner hasn't got enough money to pay a fine, to post a security, it's your business. Us, as underwriters, will not cover this thing, okay? Ordinary judicial process. What is ordinary judicial process? Is the typical situation where the courts are basically spectators or a device by which two private litigants go to the court and ask for an order. So whenever there are two private parties who litigate each other and after which an order against the vessel is issued, this would not be covered by the war and strikes. The reason is that the underwriters will not cover any contractual liability. What is a situation like this? Cargo claims, a vessel arrives, there is a cargo claim, the cargo claimants arrest the vessel because they want a security, or bunker dispute, charter party dispute, whatever contractual dispute you might think about, then this is not covered. The other tricky thing, the other tricky exclusion, which actually is part of the second part of my slides, is the breach of trading and custom regulation. Whenever a vessel incurs in a breach of the local laws, which relates to trading, to commercial, to navigation rules, this would not be covered by the war and strikes. I'm talking about the local laws in which the vessel is navigating and where the order is issued. Well, the example I think has been drawn earlier today, was the drug trafficking, I think, in some occasions. Moving from this, I will move to a real fact case. I hope it was, I know in 10 minutes it's impossible to give a glance of all the insurance cover, but this is the scenario, the picture in which we are moving. Let's move to a real fact case. Well, it's not really a real fact case. It's partly real because the vessel is, the case is still open, so I cannot disclose the name and not many details. Part of it is fictional, just for the ease of the audience. But it's a typical situation which an owner might find when they go to the Persian Gulf. This is a case where the owner has got a vessel who is trading in front of the Iranian coast, is not calling into the Iranian waters, just trading in front of the Iranian, of course, because it's in the Persian Gulf. The vessel suffered an engine breakdown. So what happens? They stay there, they try to restart the engine, they didn't manage to do it, called the owner, said, please owner, send me some tags. The owner sent a tag, which is a sister ship. The tag arrives. Unfortunately, also the Iranian National Guard with the tag arrives. And they force the convoy to move to an Iranian port, where the vessel is stuck there. The crew is taken off the telephone, computers, laptop, IES switched off. So they are completely cut off from the owners. What does an owner do? They go to their P&I club. I said, sorry, my crew is in danger there. Could you help me with that? No, I'm sorry, I cannot help you because you are in Iran. We haven't got any connection with it. It's your business, which is a nasty thing, but actually happened. So the owners had to find the local mediator, let's call it, in order to negotiate the release of the crew. They paid a lump sum for the release of the crew. The crew were released, also the tag were released, but the vessel remained there. So 12 months has elapsed, and the owner said, the vessel has been captured, has been there for 12 months, so now you give me the total loss to the war underwriters, okay, the underwriters of the vessel. But unfortunately, the underwriter said, no, I'm sorry, I will not give you anything for the time being, because you have to prove that it was a capture case. In this particular case, the master was served with a piece of paper written in Farsi language, which was asked to sign. As you can imagine, the Iranian National Guard asked you in a polite way to sign it. And he had to sign it, he was not handed over any kind of piece of paper. When he was sent back, he was not given any evidence at all. So the owner was unable to provide any evidence for the actual capture, because in a normal world, what happens? When your vessel is captured, you provide the court order to your underwriters and you say, this is the reason why they capture. So there were some issues to discuss about. So what was the actual cause of the loss? Was it covered? But the difficulty is that we are in Iran. In Iran, the only thing that you would do is, in a civilized country, I'm not saying Iranian are not civilized because I don't want to offend anybody, but it's difficult to find a lawyer in Iran for two main reasons, and the owners didn't manage to. First of all, because they want to be paid in advance, so just try to make a remittance to an Iranian bank account. I'm sure you will not made. Second thing, the Iranian lawyers are exposed or affected by the local political power. So it's quite difficult to find a lawyer which goes against the political power. So the onus is, in fact, lacking any formal evidence on the reason why, well, not only the reason, but also on the very fact that the vessel was captured. So is trying to provide clear evidences. They might provide ancillary evidence by local situation in Iran. They might use windwords for reports about the movement vessel before, so proving that the vessel was not trading in Iranian water, these sort of things. But the case is still open. And the underwriters haven't taken a view yet. There was a difficulty on this case that the specialized press, the English one, I'm not blaming in English, of course, but just because the most important newspapers in the sector are English, leaked the information that the vessel was taken for smuggling. Which, even if it was true, for sure it was quite strange that the vessel was taken into the Iranian water, despite being in the international waters. In any event, was it actual smuggling? Because I assume that smuggling is the same reason that any kind of political power would seize your vessel for. So what's the distinction between a real case smuggling and a fake one, let's call it? One is not covered, as we said before. The other one might be covered. I will not be too lawyer on this, and forgive Ian on this, because I'm trying to be a sort of English lawyer. But there is English case law about this, two famous English case law, which were pretty clear in distinguishing the two situations. When a court is just applying the local rules, whether fair or good or not, but they are local rules, and the court use and apply them as they are, this would lead to an infringement of custom duties, custom regulation, and would not be covered. On the other hand, when the court is just issuing an order under the political power, so they basically issue an order which is completely outside the local law, they acting like puppets, let's say, in the hands of the political power, then there might be room for the owners to argue that this risk is covered. As I said, the issue is still open, but you can understand from this that in order to displace these sort of things, you have to instruct local lawyer to get advice, and it's very challenging for the owners sometimes to do that. So I just want to give you some food for thought about that, and I'm sure that Ian might have some more intelligent things to say about this thing.
I wouldn't be that sure, Guglielmo. Thank you. Just a couple of thoughts really on that, and comes back to the construction, the way the war risk policy is constructed. There we go. So the first point there. So this case that Guglielmo's talking about, clearly you're into capture or seizure. The vessel has been stopped on the high sea and redirected. So the English marine insurance policies are what are called named perils. So what we have here are the so-called named perils. So the owner who wants to claim on the policy has to, and this applies whether it's hull or war risks generally, they demonstrate that the ship has been seized. That is a matter of fact in this case. It seems to me the ship, you would be able to demonstrate by AIS, amongst other things, that the ship was in international waters and was taken against the will of the captain into a foreign port. And then the way it works is that then if the underwriter wants to rely on one of the exclusions, it's for the underwriter, that the job is for the underwriter to show that one of those exclusions applies. So if you like, the burden shifts from the owner saying this is under a named peril to the underwriter to be able to show that it's been one of the exclusions operates. And then really it becomes a question of evidence in this case. This case would turn on whether that exclusion applies. And as Guillermo says, it's really a question of evidence. You can't have it's very difficult to get any real evidence from the Iranian system. All you really have is a signed statement in Farsi taken on any objective view under duress on the one hand. But other than that, there's no real evidence as to smuggling in truth. So I think that was where, if I was an owner, that's where I would be taking it. On the one hand, you would be able to build up, no doubt, quite a wealth of evidence spanning many years as to all the activities of the Iranian Republican Guard. The British Navy amongst NATO forces have been up in that part of the world for quite a long time, trying to protect freedom of passage and what have you. So I think one would like to think more of a problem for the underwriters in that particular scenario.
Can I ask you something, Ian? Because one thing I didn't mention to you, then when the owner went to the P&I club and said, okay, guys, you didn't help me to retrieve the crew, but I paid for something, so I want to be compensated, because at the end of the day, I saved the crew, and otherwise you would have paid for their lives. And the P&I club said, so I'm sorry, you're not covered. Ransom is not covered under the P&I club rules. There is only Bruce rule. So do you have any comments about that?
I think that's quite...
This is not prepared question. I'm just giving an advice for free.
The clock is running on my phone. I've started. It's quite a selective operation of the omnibus rule. It seems to me. The industry has been paying ransoms to free, crews from Somalia for 20 odd years. So it's quite a strange way to go. I'd be fascinated to know the background to that, but.
Technicality with that, though, in that with Somalia, the problem was you can't, governments won't allow you to pay ransom for terrorism. So we're trying to avoid Skype terrorists, but actually you're paying the ransom in order to get ship released.
Yes, it's quite as you say, a bit of a technicality. One might say, are we supposed to leave the crew?
Yeah.
In Iran, I mean that's the
Fringe the UK Bribery Act, because you start paying ransoms here and there, and you entice all the crime doers to follow and to double and to triple their ransom demands. Yeah, that's a very tricky question. We don't want to get into Q&A yet. That'll be left for in about 20 minutes to half an hour. Let me move on, if I may. Can I hear? Yeah. Well, ladies and gentlemen, that was Guillermo Camera. Complemented by Ian Tier, who is a partner at Hill Dickinson. You'll see Ian tomorrow because he's supposed to be at panel 4, but he sort of pirated into our panel today. Just to add on a few words of what Guillermo was saying about that very interesting case. Thank you. Lawyers, they would dissect the word into bits and pieces like the physicists do with atoms just to make money. And that's what lawyers do. Did I say I have the legal background? No, I didn't. I have the legal background. So turn to lawyers every time you're in doubt, and you will succeed in this life. Anyway, we're moving to our exciting part. And again, I draw your attention to Figen Ayen, who, as I mentioned, is now the honorary president of MedCruise. Figen and myself met last year at the 63rd General Assembly of MedCruise, which was held in Bulgaria. I was a panelist then, and she was a very important figure. Now, Figen is interesting for us because she's probably the only figure, or hardly the only. There's one more lady who's representing the cruising industry, but she will speak about shipping from cruising perspective. And most of us are merchant shipping people, i.e. cargo, but she's going to talk about how the cruising shipping industry addresses the geopolitical issues in hand. She's prepared her presentation a bit more for the innovation and technologies, but I leave it to her. Figenayen.
Well, thank you very much for the invitation, first of all, for the Chamber of Shipping. Also, I would like to have a special thanks to Zdravko and Svetoslav, because actually they didn't only organize an amazing event, which is going to create a lot of connections, but in the same time, they showed me the beautiful city of Varna that I have discovered for the first time yesterday. Yes, indeed, Bulgaria is a wonderful country, and we discovered it with Maria, thanks to Maria, with Burgas, where we organized actually Med Cruise General Assembly. So I couldn't wait when Yarov called me a few months ago. I couldn't say no, in a way. It's going to be much lighter than actually my other fellow panelists, and I'm super impressed by actually your presentations, because these are super serious and difficult and challenging issues that you are all covering in a very concise manner. So I'm going to be a little bit light up with Galata Port Istanbul. Yes, it's about innovation, but in the same time, talking about conflict and challenges, I have to say that geographically we are not in Sweden in a way, or in the south of France, in the French Riviera or the Adriatic. So when I was a tour guide and people were coming from all around the world, geographically speaking, we are at the crossroads of many civilizations, many cultures, which is making the richness, but in the same time is making the challenges. So from the cruise industry perspective, you are a static port, and you have visitors who can shift their ships like that from one day to the other. So you need a kind of flexibility. And over the years, 30 years ago, there were only ports, and we were only talking about our terminal building and our fenders and our pier length and our draft. But we have started expanding the port concept to create some whole environment and a whole ecosystem, which is an integration of the local community as well, like Burgas is. So when you are right, or like Varna as well, when you are right in the city center, a few steps away, in a way, you have to have this flexibility. And Galata Port Istanbul is right in the heart of the town, across the historical peninsula where millions of people are visiting the city for. And that's why we have expanded not only our activities, but also to create some side revenues. So I don't know if it would be able to work for commercial ports, but I think that we have to think outside the box and create some new revenue streams so that we can survive whenever there's a conflict, and there will be conflicts. Obviously, because of our location. So, like I said, we're talking about a 1.2 kilometer waterfront, which was only a cruise port when it was privatized. The privatization process is very proactive in Turkey. Most of the ports are just privatized so that actually the financial and the innovation aspect can be injected in this governmental ports. And this is exactly what happened in 2014 when this area was privatized. This whole area was a custom zone. It was an ugly area behind fences. And we decided actually to build up our terminal building under the ground as a first in the world so that we could release the whole area to the public, to the tourists, to the crew, to the passengers as well. So when the engineers and the architects came to me and told me, Figen, we're going to do the operation 8.5 meter under the Bosphorus, I said, I mean, these people are totally crazy. They ate their brain for breakfast or something. But actually, it was a journey of about 10 years where I was from day one involved in the terminal design, in the passenger flow, where the luggage are going. And it was a crazy story. But we're talking about 29,000 square meter of terminal area. And we can accommodate 3 big cruise ships and simultaneously 15,000 passengers. The day I was in Burgas, my team just served 15,000 passengers and in October 2023. So we achieved this goal. So we got many awards for it. And actually, we have to say that it was really an activation of the whole area. And as an example, as a practical example, you have to tell me how many minutes I have as well. Oh, yeah. I can continue until morning, actually. My CEOs are just like, God, stop talking. So, yeah. So what has happened is that from a place which was totally close to the public, and when I was a tour guide, when I wanted just to take a bus to the historical peninsula, they were checking my criminal records. And then I could enter in an area which was actually the apron in a way. From that world, by shifting the whole terminal building under the ground, we had the ability, and we have now 30,000 on average visitors per day in this land, which was totally secluded from the city. This number goes up to 65,000 on average on weekends. And I wanted also to give you the numbers here about what a cruise passenger is spending per day. In Turkey or in Istanbul, a tourist coming by plane is spending about $60 per day. A cruise passenger coming on home port is spending about $400, about 8 times more. And the crew members, which are always in the shade, are spending $70. So in a way, you're just activating the whole waterfront, a 1.2 kilometer waterfront, where the local community, the tourists, the crew are just joining together. So for a cruise company of 3,000 passengers, to give you an idea about the numbers, and I love numbers, for 10 calls, the government and Galata Port Istanbul might earn for 10 calls about $5 million per year for one cruise line. But with these numbers, these tourists and crew would spend $40 million. This is only one cruise line. That's why it was so crucial for Maria and the whole team just to welcome Med Cruise Association General Assembly so that we could activate the cruise industry and the tourism in Bulgaria in a way. These are some, information about the interior. But the thing which is really funny, I would like to draw your attention on, because it's not only the expenditures, the touristic expenditures of the passenger and the crew is also the ship. When a ship is coming in your city, they have a big list of items, of shopping items. 1 week is 9,000 kilos of red meat. Before the life of Galata Port Istanbul, they were not doing provisioning in our port. These cruise ships were not coming for provisioning. But right now we have the ability just to have an impact, economical impact, with actually the provisioning area. That's why it was important for us when we were designing the terminal to make sure that we could just supply this type of activity. I want to show you a video, which is just 1 minute. It's not too long, and we'll be all together talking about. So just as a recap, because I have been emigrated, and I like this word, Yavor, emigrated from another panel to this one, but I think that the geopolitical challenges will be persistent no matter what happens. But actually, it's through this type of networking and through this ties that we are creating between the countries, and on a smaller level that it's impacting the governments. I will give you a last example before passing to the video. Back to 2021, right after the pandemic, the Greek government decided just to seize and to close the borders between Greece and Turkey. Any cruise ship coming from Greece or coming from Turkey or going to Turkey was not allowed to enter in the Greek waters. So the pandemic was behind us almost. Let's say we're talking about August 2021. But I couldn't have any ship in my port, which was brand new. We finished it. We spent $1.7 billion, but I couldn't have any ship. So I called the previous MedCruise president, Aris Batsoulis, and I told him, you have to help me here. We have to create a ties between our government and yours. And this is the moment where we have started like bees working with the General Secretary Amelia Aris. We discussed with the Turkish Ministry of Tourism, the Greek Ministry of Tourism, and it was months of bilateral connections, which ended up with the announcement on the 13th of September of the Greek Minister of Tourism saying that he was opening the doors for Galata Port, Istanbul, and Kuşadası as a first step. It was big time. And on the 1st of October, we got our first ship, and it will be finishing, the video will be finishing with it. What I mean by that is the governments can just talk and just do their own thing, but it's just these ties and these connections which will just resolve our immediate challenges and which will help also avoid growing. That's why it's so important to be all together here. So thank you very much for listening to me.
Thank you very much. That was wonderful, wasn't it? When I called again, I think it was 2-3 months ago, I was in Geneva, and she said, please don't talk to me, it's Bayram Kurban, I can't speak now. Anyway, I managed to motivate her to be here because I was sure she would do something different. And when I met her last year, I spoke with some of her environment and colleagues, all people of the cruising industry, and me coming from the cargo shipping, they said to me, you should move to the cruising business. It's the sexier industry. And indeed, this is the sexier industry, so fresh and so colorful. Whereas we deal with cargoes and bulk and break bulk and containers. Come on, I mean, oh, yeah, well, I've done enough. I've done 20 years. Maybe it's enough. Anyway, it's finally probably to give the floor to myself as I've prepared something for you. I mentioned I have a legal background. I worked in an insurance department since 2005 till nowadays. And well, this is a SHIPPOSSIBLE branded presentation. I'll try not to be dry or boring. I have focused on marine insurance and what this is about. I'll try not to tire you with too many details. I'll follow the example of Guillermo and Ian. Let's start. And as an ending, we'll wrap the panel up with the CEO of the P&I Clubs, Nick Shaw, who has recorded a video message so kindly for us. Let's start. Okay, I'll just start with a few takeaways from when I was a student. My first takeaway is from a lady who still works at GARD. She's very senior. She was giving a presentation in Geneva and she said, don't trust the contract on its face. It may look too good, but if it's good from far, it may be far from good, depending on what's inside. Ian, you're laughing because you know you're dealing with contracts every day. Now, another professor of law, Mr. Huybrechts, he's quite senior now, a Antwerp-based professor, said that, and it really stuck into my mind, law is all about transferring liability. You're guilty, no, it's me. You're guilty, it's me. And wherever the ball ends, he pays the bill. Isn't that right? So you're trying to transfer the liability to another party. A non-practicing barrister, Peter Chart, he's still at GARD, maybe he's pensioned, I have to call him, but he said to me, there is nothing that special about law, it's all about reading the words. They are on the paper, they are in the contract, read the words in black and white, you'll know what this is about. Anyway, I've titled this presentation, Marine Insurance Casino of the Learned. Why this is a casino, we'll find out. Why the people call themselves the learned? Is it the learned or the learned? Simon? The E, is that it? Is it the learned? Learned. All right, let's do the learned. The types of cover, and then I'll briefly walk you through a case that I was appointed to consult on. What's the typical casino? The gambler walks in, he pays money, he buys chips, he's given an opportunity to gamble. And if he has luck, he will walk home with some winnings, yeah? Okay. What's the insurance casino? The assured pays money by way of premium to an underwriter, and the assured buys the right of signing a contract with that underwriter. He doesn't use his luck, but the triggering event is an insurable event called either a loss or a liability or a damage. If that occurs, then the assured who has paid money or bought chips from the casino has a right to be paid a claim. Now, probably the most important commercial question in the insurance world is how much is the premium and how much is the claim? Insurance people like to think, underwriters like to think, well, we should make money because we're underwriters. By getting premium after premium after premium, we should be on plus. The assurers or the ship owners like to think, well, we should profit from insurance. So these are two contradictory beliefs. And people like us who are intermediaries or consultants or brokers should try to find the best in the both worlds and try to mediate between the client, the ship owner, and the insurer. Now, insurance is not obligatory, which is a very peculiar subject, particularly protection and indemnity insurance, which is the liability insurance, like your car liability insurance, is not obligatory, but it is a license to trade. Try to have a ship going to almost any jurisdiction in the world without a P&I certificate. Would that be possible? Probably not. Now, why this is a casino? Because you are getting money for engaging with an obligation to pay money if a loss occurs. Now, within the insurance companies and world, there are that many experts working on highly proficient fields such as cargo expertise, metallurgists, chemists, fire experts, forensic experts, all sorts of loss prevention experts. And all these people need to assess the risk to see if a client or a ship owner will be credible enough or claims intensive enough to say yes to the insurance contract or not. So it is a casino, but it's a casino of a very highly specialized people. And these are the highly specialized people in the English courts named barristers. Now, Ian, you must be a solicitor, if I'm not wrong. Now, what's very briefly the difference between solicitor and barristers? Solicitors are the more closer to the client's lawyers who are commercially minded and should guide the client how to solve the case, whereas the barrister is supposed to sort of read the mind of the judge and be able to predict what the judge will say in the most accurate way, in a way. The barristers would also have hearing rights in courts, and they call themselves my learned friend in court. I had the chance to be in English court back in 2007 while I was doing a secondment at a law firm, and I heard a lot of that phrase. Anyway, the types of shipping insurance, probably the most essential one is what we call casco, or hull and machinery. What does that protect? It protects the very ship, the very asset, nothing different than the machinery and the hull. This is why it's called hull and machinery. The ship, of course, earns daily hire or freight, depending on the contract of carriage, but the loss of hire can be protected. In other words, the ship owner, if he starts losing money day by having his ship in repair, or the ship is in distress, or stuck at sea, he turns to his underwriter and says, I have a loss of earnings or loss of hire insurance, pay me back what I'm losing. Loss of hire insurance, LOH. That's my favorite part. Liability, protection and indemnity, P&I. This is the liability of the ship owner against almost any third party, including the crew, because the crew is a third party to the ship owner. If a crew member breaks a finger, it's a claim. If a crew member dies, it's a claim against the ship owner. Ship owner sends the bill to the club pays the ship owner pays the crew member. That is probably the most down-to-earth and probably the easiest to understand insurance, commodity insurance. They call it commodity in the trading world. In the carrier's world, it's called cargo. Cargo, commodity, the same thing. So in cargo insurance, you are insuring these colored boxes. They are named containers. And now we come to the exciting part of this, where probably Guillermo's presentation crosses with mine a bit. War insurance. Now, we have a few wars going on. It's the Red Sea now. It can be the Purple Sea tomorrow, the Green Sea next week, but the principles would be the same. I'll walk you through them by saying that war this, war that. In other words, you can attach the concept of war insurance to any sort of risk you're covering. If you're covering the hull and machinery, anything that has to do with war would be called war hull and machinery. If you're covering the loss of hire, then if it regards a war situation, would become war loss of hire. If you're covering P&I, then anything that has to do with war would be war P&I, and logically the cargo would become war cargo. So to simplify this, when a ship crosses a war risk area or a war intensive area, any risk that is associated with the marine voyage would be distincted into war cargo, war loss of hire, war hull, war P&I, okay? Not that difficult to understand, I hope. typically what we see as intermediaries and consultants from clients is requests to quote the cost of war cover in the following areas of the world: Russia, or as they refer to it, RUB, which is Russia, Ukraine, Belarus; Lebanon, Israel, Gulf of Aden, Libya, Venezuela. Venezuela is a tricky one. Some ports like Puerto Cabello are excluded by the Joint War Committee, JWC. Others are not. So you need to really know how to address these queries. But mostly the simple question is, we're going to a war zone. What would it cost us if our ship gets into there for 5 days, does its job, goes back? And then we say, well, it'll cost 0 point something or 1% above, very roughly, and then the bargaining starts. We talked about some bargaining, Simon and the Ron, about bargaining and AI. This is why I asked, can AI do bargaining really? Can really negotiate? So the procedure is the client consults the broker or the intermediary. The broker gets quotations from the market, returns them to the client. If the client's happy with the pricing, they sign the slip. It's called a slip at Lloyd's, and then the war cover is already out. It's taken out. And on basis of that war cover, the client has a policy, and the insurer has a liability to pay if something goes wrong. Let's say the war cover costs $1 million or 1.2 million for a 7-day period. That sounds like a huge amount of money. When the Ukrainian war started, I had a charter who asked me, what would it cost us for 7 days to go to Ukraine? And the price was $1.2 million. Client was stricken. They couldn't believe they had to pay that much money for a 7-day job. We'll get to that in a minute. When I tell you about the case I was appointed to consult a month ago. So I get called by a law firm, and they say, we work for that client, and that client asks us to advise whether their ship, which was hit by a missile in the Red Sea, can recover money from war insurance. And I say, okay, let me see the papers, let me see the slip, let me see the policy, the communications with brokers. Was the invoice paid? And then there's silence in the room. I ask, can we see the invoice, and has that invoice for war insurance been settled? And the answer is, well, we don't have that information, we can't tell you. Which leaves a blank spot in the whole analysis. We continue to analyze, and we realize that there is a real valid war insurance in place. The insurance was in place. However, what happened is the client tried to be a little bit too smart. So they called up underwriters, war underwriters, and they say, our ship is going to Europe. Which is a very strange thing to do, because you never call your underwriter and you never advise your insurer where your ship is going. You don't have to do it. It's not compulsory within the policy, and nobody expects you to inform your insurer where your ship is going. And we get to that, and I ask, well, why was this done? The answer is, well, because our client was way too sensitive about the fact that their ship was actually going to the Red Sea, and they didn't want to expose the vessel by telling the truth. And I stayed hugely puzzled, and I'm like, how can you, first of all, intentionally fool your underwriters by giving them a wrong information? That's like a outright breach of the policy, first of all. Nobody asked you to do that. And third of all, would you really think that your insurer would call terrorists to bombard your ship? Because this is crazy. And then I thought a bit more about this, and I realized that probably the client was trying to save money by just not advising underwriters that their ship was going to a war area, because the insurance is not cheap. Yes, it is expensive cover. But by being a bit too smart, they had the ship hit by a missile. The ship was stuck in the open sea. They had to call numbers of tugs. Tugs weren't available. Tugs are super expensive, if you don't know. I work with tug brokers, and a tug costs a fortune a day. It takes time to arrive. It takes time to drag the ship to a port of refuge. And then the story starts with repair. The shipyards won't be available. They may not have the parts you need. You may need to wait for the parts from China. It's a huge story with an enormous expense. So the moral of the story is, and that's my conclusion really, I hope that I tried to keep it pretty brief for you. You think insurance is expensive? Well, then try paying a claim for a broken ship that costs either a total loss or $15 million. You have to put yourself sometimes in the shoes of the underwriter to see what he is exposed to once he's received premium. Don't try to outsmart the learned people with these figs on top of their heads, because they are really smart. They argue in court and they know what they're talking about. You as a businessman try to slip a Mickey under. It doesn't work like that. These people are smart. They are probably the smartest. They are the elite of the industry. If you are not fair, you'll fail. Insurance keeps you protected if you doubt about something, if you're uncertain whether you're breaching sanctions or you're going to a war area. Talk about this with your broker, expert, trusted advisor. And my ultimate conclusion is be honest about your business. That will always get you in the right place. That's it from me. Thank you for your attention. I do truly hope you're having a good time. My role is double as a panelist and moderator, and I will continue to moderate the panel until its end. Svetlo here will now play a video recorded by Nick Shaw. Nick Shaw is the head of the IGP&I clubs.
Hello everyone. I'm very sorry not to be with you today, but I'm sure that the International Maritime Forum, which you're all attending in VARNA, will be a very successful forum indeed. Today I'm going to say a few words about the international group and its more recent work, but I thought very quickly I would just start by introducing the international group again and making sure that everyone understands who we are and what we do. So first of all, in order to understand the group, we need to understand what P&I clubs actually are. So P&I clubs are groups of ship owners who come together to mutually insure their third-party liability risks relating to the use and operation of ships together. Each of the clubs is a true mutual structure which is owned and controlled by its ship owner boards. And the boards come together 3 or 4 times a year to decide the policy of each P&I club and to approve the changes in the rules and to set the premiums for each category of vessel. Each of those clubs is not for profit, and the aim is to provide insurance at costs for ship owners in the most cost-effective way. And the mutual P&I clubs' origins date back to the 1850s. So a lot of the clubs have been around for over 150 years, some quite a few years more than that as well. In terms of the coverage and the types of liabilities that the clubs cover, first of all, we've got contribution towards collision damage, and then in addition to that, we have damage to fixed and floating objects. On the right-hand side of the screen, you can see the Vitus Spirit, which was a bulker that ran into a restaurant in the Bosphorus Straits. I was involved in that case when I was a shipping solicitor for many years. You get some very exciting pictures in shipping, as always. In addition, we also cover pollution damage, including all pollution damage up to $1 billion per ship per incident. And this is one of the most important areas of coverage for the shipping community and also for maritime states. We've seen a number of pollution incidents already this year, and the interaction between our outreach there and the local authorities is very important to what we do. We also cover personal injury damage for passengers, crew and other parties, and also where ship owners have been negligent and have not conducted themselves properly in terms of the carriage of goods by sea, we will also cover cargo loss and the damage resulting therefrom.
Another area of very important and very expensive damage which clubs cover is wreck removal, but not salvage. So the cost of salvage and the act of saving the vessel itself, so where there's the ship has actually been salved, that's normally for property interests and is covered by the hull and machinery underwriters and also cargo insurance. However, where the vessel can't be saved, and here we've got a picture of the Costa Concordia off the island of Giglio, or is declared a constructive total loss, then that's when the P&I cover will respond and to any legal liability and of the owner to remove the vessel. So where there's a wreck removal order from the local authorities, we have to come in and organise the wreck removal. So in terms of the international group itself, this is the collective of 12 mutual marine insurance associations, each of the P&I clubs as we call them. And together they've come together to form the international group. And they provide cover for about 90% by GET of the global ocean-going shipping fleet. And presently our latest data suggests that there is over 1.4 billion GT entered with the international group clubs. We have very large clubs, Guard, North Standard, each of those have over 250 million GT, and smaller clubs as well within the group. The American club with about 21 million GT is the smallest club in the group by GT. However, each of the clubs has one vote when it comes to the international group, and so they operate together very effectively under the moniker of Collectively Stronger. In terms of our history, the first pooling agreement for the international group was in 1899, with 6 clubs joining and an individual club retention of $10,000 US. The first reinsurance agreement which we put together was in 1951, and then the group reinsurance covered a combined GT of 27 million GT. So you can see how the group has grown over the years to 12 clubs now and 1.4 billion GT. 3 main purposes of the IG are as follows. First of all is, and most importantly, is the pooling and reinsurance of large maritime claims. So each club will bear losses up to $10 million on any one claim as matters stand at the moment. And above that, the claims are pooled by the 12 international group clubs. And we also then purchase very high levels of reinsurance cover for claims in excess of $100 million. And that will take us right up to a claim of $3.1 billion through the reinsurance markets. The second key purpose of the group has been as a forum for sharing information. So what do I mean by that? Well, we have about 30 committees within the group where each of the clubs will send one representative per committee, and we'll sit around a table and look at all of the key issues in shipping and bring together that knowledge and expertise to ensure that we are giving the best possible guidance to ship owners globally through that collective experience across all of the club system. And finally, the third purpose of the group is to act as representatives for ship owners with the various industry associations, also with a multitude of bodies, both government and non-government organisations, where we will discuss and speak for ship owners on liability issues across the industry sector. In terms of our own website, and one of the key uses that maritime authorities and other parties find is to go on our website and look to see where a vessel is entered. By typing in our vessel search system, you can very quickly discover whether a particular vessel trading in particular waters has IG club coverage. By tapping on the vessel itself, you will then get taken directly into the website of that particular club, and then discover which certificates of insurance that vessel has. So maritime authorities find this extremely useful. It's the only place where you can get this information, and it's kept up to date on a daily basis. So moving on to the strategic direction of the group and where we are going to now. A couple of years ago, all the group managers got together and we looked at what are the key areas where we can combine our collective expertise and to help ship owners, where are the areas of focus for the group. And we landed on these 6: safety, liability regimes, educational outreach, casualty response, decarbonisation and sanctions, but also with a flavour of sustainability. It's very important that we have a sustainable IG pooling and reinsurance structure for the ship owner members. So that is another key area which goes through all of these 6 pioneer areas on our group strategy. Turning to the first of those, safety and decarbonisation. First of all, in terms of safety, we look at crew mental well-being, and we have seminars to look at how the group clubs can help seafarers at sea to ensure that they are working in a safe environment, but also they are looking after themselves. So we're very focused on that, and we have a number of committees, including Ship's Technical Committee, where we will produce animations and also other guidance for seafarers, together with the other industry organisations involved in safety, to ensure that seafarers have a safe environment within which to work. We're also looking more and more at enhanced data collection to see where we can use the collective data that clubs collect to improve safety standards. And we'll be doing more work on that as time goes on. Turning to decarbonisation, what is the group's role there? Really, it's the power of pooling. As we've already seen, the group ensures the highest levels of risk, and we want to make sure that we're doing that for all new types of vessels running on new fuels. So we want to help support a safe transition to these alternative fuels and make sure that we are working together with the regulators to ensure that there is a proper legal infrastructure to support ship owners as they are trading around the world. In this regard as well, we have our second sustainability report, which is coming out this September, which puts out in a bit more detail the sustainability work that the group is involved with. Another area where we have spent a lot of focus over the last few years is our education outreach. First of all, we helped develop our own exam. We have 8 modules in our P&IQ qualification. This was established in 2010, and now we have about 1,000 people every year taking our exams. They can be a combination of club personnel, regulators, insurers, club correspondents, club lawyers around the world, all looking at our exams with a view to improving their knowledge of the industry and in turn giving a better service to the ship owner members. We're also presently developing a P&IQ for seafarers, particularly the seafarers that want to come ashore and work within the maritime industry, but in particular the P&I industry in due course. We've also worked with IMLI to develop a fellowship there, and there's a picture of me with Patience Diaba, who's our present fellow scholar, who is sponsored by the international group to go through the IMLI exams, and will then go back to her jurisdiction, help to support the IMO conventions in her country. So this is a very important part of our educational support. And off the back of that, we've looked at further outreach and building relationships with various maritime-focused educational establishments around the world. And recently, we've signed MOUs with the Shanghai Maritime University, with Tulane Maritime University, and we have 7 institutions now around the world who have our MOUs and are helping to promote P&I on those maritime courses. Another area of key strategic focus for the group is in supporting the IMO's liability regimes. The international group has a long-standing relationship at IMO and is one of the most active NGOs down there, with a key industry voice on issues of liability and compensation. So we get involved in helping nations to understand what the impact of the regulations may be, putting forward the voice of ship owners, but also understanding the needs of maritime nations and what they are their imperatives going forward, particularly in the ESG space. So, for example, as well as supporting those limitation conventions, we've also helped to develop a unified interpretation which exists to ensure that the right to limit liability is upheld so that ship owners are able to know and be confident when they go to sea that their limitation will work when an incident occurs. Of course, there is that very important balance between getting the levels of limitation correct on the one hand and making sure that legitimate claimants are paid out on their claims, and on the other hand, ensuring that there is proper insurance and reinsurance cover for vessels going forward, particularly given the present geopolitical environment. And we're also very much in favour of unified regulation globally for ship owners. We think this is very important and that regional regulation makes it much more difficult for ship owners to understand what they need to do in different countries. If we have a hodgepodge of different regulations around the world, life becomes much more difficult for everyone. Another area where we have spent a great deal of time and effort is in understanding and really helping maritime authorities with casualty response. Pooling and reinsurance function of the group, we have the financial strength to respond to the very largest casualties. The biggest incident that we ever had was the Costa Concordia wreck removal, which you see at the bottom there. But we've been involved in a number of other wreck removals around the world. And these are very complicated operations, therefore very expensive. And we need to ensure that the environment is not impacted when one of these incidents takes place. So the role of the clubs is to work together with the ship owners and the maritime authorities to provide an immediate casualty response, looking after life first and foremost, and then pollution response after that. That then moves towards bunker removal, caretaking of the wreck, and then the eventual wreck removal and recycling, which is a very significant logistical operation in every single place, often in quite remote locations. And then ultimately, we'll look at site remediation and restoration and regrowth of the maritime habitat to ensure that there is a sustainable maritime habitat going forward. How do we go about doing that? Well, what we do is we speak to the maritime authorities around the world and we're looking to establish key contacts and build relationships with those authorities, improve the communication channels, and then work together with those organisations to provide workshops to promote an understanding of P&I insurance and the group's experience with large casualties. So there's a picture at the top there of me signing an MOU with the UAE Minister for Shipping in front of Kitak Lim, who was the IMO Secretary General at the time, down at IMO's headquarters. And our aim is to formalise our engagement with authorities and then work together with them to really understand each other and what we can do, what we can't do, but also what are their imperatives in terms of maritime incidents and helping to make that more uniform across the world. Our ultimate aim here is to facilitate a timely and effective response to all major maritime casualties. Separately from that, our pollution committee also has a huge outreach program looking at spill response and working together to help nations to understand the IMO conventions governing liability and compensation and how those work. So we work very closely with ITOP, who are the chemists and engineers who get involved in most of the big marine casualties. They're the real experts on pollution cleanup. And also with the IOPC funds who are based down at IMO in order to help train and work with those governments to enable an effective response to any pollution incident, whether it be oil or some other pollution product. So far, we've had 50 plus pollution-focused workshops and seminars with governments in the last few years, and we've worked together with over 70 countries since 2015. So there's been a great take-up, and this is ongoing engagement. And finally, just a quick word to say what we're up to going forward. We're looking very closely at autonomous vessels with a view to understanding the risks and the regulatory environment within which autonomous vessels will work, and also then providing guidance to the ship owners around the world, and also working together with the other industry organizations to make sure that there is always a safe environment for new vessels as they hit the water. That similarly applies to alternative fuels, which is going to be a big topic in the next 5 to 10 years, whilst we still go through the research and development phase. So we're working to understand the risks in respect of each of the fuels, then helping governments and the IMO to build the legal framework to enable ships to trade with those alternative fuels, knowing that they will always have the highest level of cover should an incident arise. So our work is never done. The geopolitical environment has made things quite tricky in the last few years, but we are an apolitical organization, and we look to cover all vessels around the world wherever possible. So thank you very much for your time today. I wish you a fantastic conference, and again, sorry not to be with you in person. Thank you very much.
Yes. Well, I'd like to thank you for your patience. When I called Nick on the phone to invite him, he said he won't be able to attend because he's committed to a different agenda. But anyway, he's made sure that he's very deliberate and very detailed about what the IG P&I clubs are about. With his presentation, this panel comes to an end. I hope you're not starving too badly, but there's ample time for us to enjoy the afternoon in beautiful Varna. Hopefully the weather is fine. I want to thank my panel, really. All exquisite speakers. Please applaud them. I am Yavor. We're going to continue tomorrow with the conference part of the forum at 9 a.m. in the planetarium of Varna. Please follow the agenda, refer to it, and you'll be guided accordingly. Okay? See you soon. Yeah.